Anna Reynolds claims her son was injured when his father let him ride a motorized scooter, and she now wants to transport their hospitalized child to an out-of-state specialist.
All rise.
David Reynolds says he thinks it's unsafe to move his injured son.
Court is now in session. The Honorable Judge Lauren Lake presiding.
You may be seated.
Hello, Your Honor.
Hello, thank you, Sean. Good day, everyone.
Good day.
This is the case of Reynolds versus Reynolds. Ms. Reynolds, you are suing Mr. Reynolds for $25,000 due to medical costs. You say the defendant allowed your son to ride a scooter, which led to injury, and the defendant, you say it was an accident, and you are paying for the rehab and the travel costs. Is that correct?
Yes, Your Honor.
What happened?
So we share joint custody, and on holidays and planned visits, Paul, our 12-year-old son, visits David in San Francisco, and we reside primarily in Knoxville, Tennessee. He was visiting his father for one of these pre-planned visits back in March, and it was a tech-related convention of some kind. Basically, Paul won a scooter at this convention and was so excited to ride it. And being the scared trauma nurse that I am, I just was like, no, absolutely not.
What type of scooter was it? Was it one of those, was it like a moped thing, or was it like the scooter with the flatbed and the wheels?
With the flatbed and the wheels.
Okay.
It had an extra kind of like motor on it or something that made it go faster than the normal.
And so you're saying that this scooter is what your child was riding when he got injured?
Correct, Your Honor.
Who was with him?
David was with him, Your Honor.
Mr. Reynolds, can you tell me a little bit about the accident on the scooter?
Yes, Your Honor. The scooter was, like mentioned before, was won at a convention.
Okay. Who won it, you or Paul?
Paul won it because it was a kid-friendly convention where they had a lot of impressive tech there.
And so what age group was this scooter for? He won it at 12 years old?
Yes, Your Honor, but the age group is, I believe, around 9, 10, because it has a motor, but it's not a super strong motor.
And so we got the scooter. Mom testifies that he called so excited he got the scooter, she already didn't love it.
Correct.
But he wanted to ride it.
Yes, he was very excited for
And
it.
at that time, he was with you.
Yes.
And so take me to the day the accident on the scooter occurred.
I was walking, he was riding on the sidewalk. It's a nice neighborhood, not many cars coming by. And a split second, he's riding the scooter. I look away for a split second. By the time I turn back, I realize I'm running towards him because he collides with the mailbox. As soon as I see him collide, I start running over. But by the time I get there, he's already on the floor and he's not responding.
And at that point, he's out cold? He's
Correct.
not responding?
He's unconscious, yes.
So you have to call 911?
Yes, I called 911.
Did he have a helmet on?
Yes, he had a helmet on, but it might have not been the greatest helmet.
Okay. What happened? What happened to Paul?
It's hard to talk about. Paul was immediately induced into a coma, and he was there for 4 months. Very recently, thank God, he woke up, but he is currently only responding with blinking to yes or no questions. He recognizes our voices, and that's great, but that is all the progress we've seen in 4 months. And I got that call, and I was livid. I jumped on the next plane there.
This is the moment the case turns from ordinary parental disagreement into every parent's nightmare. Paul was 12, riding a motorized scooter, wearing a helmet, and then in one split second, everything changed. Now, legally, that split second matters. The court has to look at whether David acted unreasonably. Was the scooter age appropriate? Was Paul supervised? Was protective gear used? Did David ignore a known danger? We hear that Paul had a helmet, but David admits it may not have been the greatest helmet. That line hurts because it captures exactly how these cases work. A parent can make some responsible choices and still face questions about whether they did enough. But accidents, even tragic ones, are not automatically negligence. The law does not usually punish someone just because the outcome was terrible. It asks whether the person failed to use reasonable care. And that is where Judge Lake is going to have to draw a very careful line.
This is this is such a tragedy. So he's still incapacitated right now.
Correct, Your Honor.
And what is the prognosis?
David's people say that his team in San Francisco, where he is currently, say that he is doing better than they expected, but at the rate at which it's been going, I personally, as a trauma nurse, don't see it being
What
better
is
than
the
it could be.
injury? A head injury?
It is a head injury, yes.
And so when you come to court to sue your ex-husband for $25,000
Yes, ma'am.
in medical bills, these are medical bills you've already paid.
No, so these are medical bills to be paid for, as I am seeking exactly $25,000 to move his care from San Francisco to Tennessee, where there is a pediatric neurological trauma therapist that I am very familiar with, who has quoted me at $25,000 and estimates that his prognosis can be pushed up to 4 months instead of a year, or roughly 2 years.
But is this guaranteed? No.
Coming up.
Why do you feel, Ms. Reynolds, that it's important to move Paul at this critical time?
The truth of the matter is, I do not trust David. This is the third instance in which our son has been hurt under his care.
And later.
You remember getting a message about interest in the sofa?
So she messaged me on Facebook Marketplace. We agreed to meet the next day so she could look at it and pick it up.
If you'll be in the Los Angeles area and want to bring your case to court, call 1-888-552-6878. You're watching Emmy-nominated We the People with Judge Lauren Lake. We're back with the case of Anna Reynolds, who is suing her ex, David Reynolds, over their son's medical care.
You got a second opinion. You want him to be under the care of doctors that you want.
Yes, ma'am.
All right. May I see your evidence, please?
Yes.
Did you bring any evidence, Mr. Reynolds?
Yes, Your Honor. I have evidence that I believe I trust more than what was mentioned.
you.
I did make an attempt to meet her halfway and use the insurance to get Paul over to Tennessee, but it was denied by the insurance. And
Okay.
because of his state right now, I don't think it's safe for him to be transported all the way to Tennessee.
Who's paying for the medical expenses now that are over and above what the insurance costs are?
I pay, but we haven't gotten a final bill yet because he's still there. But I will also have to look forward to paying that as well.
All right, so you're paying medical expenses. You're also paying for Ms. Reynolds' travel.
Yes, and her hotel.
Why do you feel, Ms. Reynolds, that it's important to move Paul at this very sensitive and critical time?
The truth of the matter is, I do not trust David. This is the third instance in which our son has been hurt under his care. Yes, it is a very tense time. It is very critical that he is not jostled or, heaven forbid, more damage goes to his brain, of course. But the last 4 months have been hell, going back and forth. And knowing the community that I'm a part of, the profession that I go in and out every single day, and I see the trauma that goes toward these children that come in every day, these adults, and I know that it will just ultimately, it has already impacted Paul's neurological capabilities, and we don't know what that's going to look like yet, but I do feel very strongly, in my professional opinion, that now is the best time to move him as opposed to later.
See, the court's issue is this. Mr. Reynolds has admitted, and he seems to have taken responsibility, not just for the actual accident, but the fact that he is paying any additional medical costs. He's paying your travel to come out to visit. I'm standing here looking at a father that has stepped up and is basically trying to help his son heal and also make sure his mother is there throughout the process. What you're suing for are medical expenses that you have not even incurred yet. This isn't money you have spent or lost. I'm trying to figure out, why are you suing for $25,000 that hasn't been spent yet?
And I agree.
It seems to me, Ms. Reynolds, that you have support. Mr. Reynolds is providing for those.
And it's working, Your Honor, as well.
This $25,000 is for speculative care.
You're right, it is very difficult to be in this position when I have been the one to take care of this baby primarily. And sure, it is because of his schooling that keeps Paul with me most of the year. But I am left with the fear and the anguish and the distrust of my ex-husband who has put him in this position before.
You're nervous because the accident happened on his watch. You're nervous about him being there and the care in being in the state where he lives.
Yes, Your Honor.
I do know you brought video
Yes.
to present to the court.
Yes, sir.
I'd like to look at that video, please.
Hey, Paul, this is Dr. Kenny. I just wanted to come in and check on you, and I know you've had trouble speaking, so I'm going to ask you to do me a favor. If you can blink once if you're feeling better than you did yesterday. Oh, thank you.
First of all, he's such a handsome boy.
Thank you.
I'm very concerned transporting a child across state lines to start with a brand new medical team that has to start all over with evaluations. We have to think about how that plays out in Paul's life. And right now, we want him to use all the fight he has to get better. I think these are situations, family, that, that's the thing. Even though you are divorced, when you have a child together, you always gonna be family. It just is what it is. And I always say the best thing you can do.
That video of Paul changes the atmosphere completely. Up until now, we have been hearing about him as the subject of a dispute. But seeing him respond by blinking reminds everyone that this case is not really about Anna winning or David winning. It is about a child fighting through a catastrophic injury. And Judge Lake's concern is very practical. Moving Paul across state lines may satisfy Anna's need to be closer to home and closer to doctors she trusts. But it could also disrupt a treatment plan that is already showing signs of progress. Notice how the judge frames the issue around Paul's life, not the parents' conflict. That is crucial. In custody-adjacent medical disputes, courts often focus on the child's best interests, continuity of care, and whether the requested change creates unnecessary risk. The emotional stakes are enormous, but the courtroom still has to ask the coldest, hardest question: what is safest for Paul right now?
Is love your child more than you hate or resent your ex. In every circumstance, that's the true gift to your child. And I think right now, given Paul's physical condition, you all standing as a united front would be the greatest foundation for his healing. Do you understand?
Yes, Your Honor.
For that reason, I'm going to deny your petition, Ms. Reynolds, with the understanding, Mr. Reynolds, that you all are going to work together to set that timeline, and if the improvement isn't where you want it to be in 6 months or so, that you will entertain her recommendations for additional medical care with her team.
Thank you, Your Honor.
All right? Judgment for the defendant. Court is adjourned.
All rise.
Judge Lake has ruled in favor of the defendant. The plaintiff's case is dismissed.
Do you have any final thoughts with each other?
No.
Please gather your things and follow me this way. Right through here.
Coming up,
We got home, we moved the couch in, my friends left, I turn on my space heater, I grab a book, I make some tea, and then I went down the hall to change into my cozy clothes, and then I smelled something. It smelled like something was burning. And so I came back down the hall and I saw that the couch had started to catch fire.
you're watching Emmy-nominated We the People with Judge Lauren Lake. Alexandra Reyes claims she bought a used sofa from the defendant and it went up in flames because the foam filling was flammable. Daniel Whitmore says the sofa didn't spontaneously combust and he's not responsible for any mishaps.
This is the case of Reyes versus Whitmore. Ms. Reyes, you are suing Mr. Whitmore for $1,884 for negligence. You say that a second-hand purchase led to unexpected damages. Is that correct?
That is correct, Your Honor.
All right, defendant Mr. Whitmore, you say you are not responsible and all sales are final.
That's right, Your Honor.
All right, take me to this purchase. Ms. Reyes, what did you purchase and how did it lead to negligence and the inference that you believe that Mr. Whitmore was negligent?
Last November, I decided to get rid of an old sofa. It was beat up and I needed a new one. And so, a girl on a budget, I went to Facebook Marketplace to find something that was a decent price range. And can I present evidence? Exhibit B, you can see the marketplace post for the sofa.
So you presented evidence to the court.
Yes.
This is the Facebook Marketplace post
Yes.
for a gently used sofa
Yes.
for $199. That's not a bad deal.
That's right.
So you reached out to the seller, which was Mr. Whitmore.
Yes.
You remember getting a message from Ms. Reyes about interest in the sofa?
Yes, Your Honor. She
Okay.
messaged me on Facebook Marketplace, and said she was interested. She just asked me how old the sofa was, and I told her, but it was in great condition. And we agreed to meet the next day so she could look at it and pick it up.
Coming up,
And was it like an as-is thing?
Yes, it was. And it was in pretty good condition because there were no stains or tears in the sofa.
you're watching Emmy-nominated We the People with Judge Lauren Lake. We're back with a dispute between Alexandra Reyes and Daniel Whitmore over a sofa that went up in flames.
Do you know how much remember how much you paid for the sofa?
Oh, I would say in the neighborhood of $350, $380, something like that.
$380?
8 years ago, right.
Wow. And 8 years later, you gonna ask for $199? All right, so she agreed to it. How'd you go pick it up?
I went with my friends. My friend Trevor has a truck.
And was it like an as-is thing?
Yes, it was. And it was in pretty good condition because there were no stains or tears in the sofa.
And do you have any pictures of the sofa when you picked it up in your evidence?
Yes, absolutely. Exhibit A, that's after I got it home. So
All right, so you picked it up, you got it home, you accessorized it nice.
Yes.
Got your little throw pillows, a little throw on there, your cat's on there. What's your cat's name?
Ginger.
Ginger's on there relaxing. The sofa made it home, and it looks pretty good for $199.
I was happy.
So what happened? Why are you suing Mr. Whitmore for over $1,800?
So after we got home, we moved the couch in, my friends left, and I turn on my space heater, I grab a book, I make some tea, and then I went down the hall to change into my cozy clothes, and then I smelled something. It smelled like something was burning. And so I came back down the hall, and I saw that the couch had started to catch fire.
Oh, and then this is
Yes, you can see
Exhibit A, this part
the second
two.
picture, yes.
Burnt to a crisp.
Yes.
And so, first of all, where's Ginger?
Ginger's safe.
Okay, great.
Yes.
Now, second of all, you're safe too.
Yes.
And you had to call the fire department, I see.
Yes. I ran to get water to put it out. By the time I was there, that wasn't going to do
So
anything.
you had to evacuate.
Yes.
Judge Lake's verdict when We the People returns. You're watching Emmy-nominated We the People with Judge Lauren Lake.
So I'm trying to figure out, why are you suing Mr. Whitmore? The sofa didn't just blow up, did it?
No. So I did have a space heater on in the room, but you can see in the conclusion the fire originated from the upholstered sofa.
So the sofa contained polyurethane foam.
Yes.
And it can ignite rapidly.
Yes.
All right, I'm looking at this fire incident report under the conclusion that the spread of the fire was because the heat from the nearby space heater plugged into an extension cord.
Oh, there you go.
The absence of manufacturer labeling prevented awareness of material composition and associated fire risk. Now, the question this court has to decide is, did you owe her a duty of care? It is this court's opinion that you did not. I don't think that there is anything about this sofa that made it defective. It's the space heater, baby. That's the thing that started cackling. For that reason, I have to dismiss your claim today. Judgment for the defendant. Court is adjourned.
Judge Lake rules for the defendant again, and this one comes down to personal responsibility in the most literal sense. Alexandra suffered real damage, and no one is minimizing how frightening that fire must have been. But courts do not award money just because something bad happened after a purchase. They need a legal link between the defendant's conduct and the plaintiff's loss. Here, Daniel sold a used sofa in apparently decent condition. Alexandra brought it home, placed it in a room with a space heater, and the fire report pointed to heat from that nearby heater and extension cord setup. That breaks the chain she needed to prove against Daniel. The lesson is practical and a little painful. As is means risk transfers fast, and fire safety around upholstered furniture is no joke. Ginger survived, Alexandra survived, but the claim did not. Final takeaway. Both cases were emotionally charged, but Judge Lake kept returning to the same courtroom principle. Proof matters more than pain. In Reynolds versus Reynolds, Anna's fear for her son was completely understandable, especially given Paul's devastating injury and her professional background as a trauma nurse. But the court denied her request because the $25,000 was for future speculative care, while David was already paying expenses and Paul's current medical team was still treating him. In Reyes versus Whitmore, Alexandra's fire damage was real, but Daniel was not legally responsible because the evidence pointed to the space heater setup, not a defective sofa or hidden misconduct by the seller. Two plaintiffs walked in with genuine losses, two defendants walked out with judgments in their favor. And the broader lesson is this: tragedy, frustration, and financial damage do not automatically create liability. Courts need evidence, causation, and a legal duty. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.